the tax. In collaboration with other institutions and actors in the land sector, like the Land Commission, we must all work together to ensure that we play our role in mitigating and in solving these complex land problems. We must appreciate that the constitutional promise of equitable, efficient, productive, and sustainable holding, use, and management of land is transformative, and it is one that promises to ensure that we maintain our environment and also our land governance system that is characterized by fairness, not dispossession, by protecting our public land from land grabbing and other injustices that have contributed to inequality and poverty in our nation. The land question continues to occupy a central place within the transformative imperative signaled in the Constitution. Transformation requires change both in the distribution pattern of property holdings and in how we approach the acquisition, use, transfer, and protection of the land rights. The court must therefore balance several demands. Justice Wanjara just alluded to our colonial period where we were dispossessed of our land, and from there we have never seen land justice. Therefore, the demands of collective justice and the requirements of economic growth and development in a country where land is a key factor of production and a means for the alleviation and the reduction of poverty are equally central. This court is expected to develop the jurisprudence that advances the goal of reversing the effects and legacy of injustices in the land sector, and also so that our social and economic development can progressively bring the changes and the prosperity that is expected. The court's impact on our society is to be assessed on how transformative and friendly the court's jurisprudence and access is and has been in the last 10 years. Going once more to mention what has been documented in the casebook, it highlights some of the landmark decisions the court has rendered in this decade. And I see an emergence of a jurisprudence that promotes constitutional goal of a land system characterized by improved security of tenure, equitable access to land, access to housing, protection from arbitrary evictions, protection of public land from grabbers, and arbitrary deprivation of property. All these cases are documented in your casebook, and they form a wonderful resource, especially for the lower courts and also for the higher courts. When we are determining issues of land, we look into it for guidance. I can say with confidence that there is already emerging from this court a line of thinking and an angle of approach to land jurisprudence that embraces and promotes social justice vision. This is the vision that we are implementing in the judiciary, which is drawn from the Constitution. 10 years of this court has therefore seen impressive progress in our land law jurisprudence, which is a steady foundation, and I encourage the court as we move to the second decade to build on that. One of the drivers of the court to create a specialized court for ELC matters was the perception that these disputes ought to be dealt with expeditiously. Kenyans felt and expressed themselves that the generalist constitutional jurisdiction of the High Court was not amenable to the efficiency and focus that needed to be given to resolve the land disputes and conflicts satisfactorily. This means that re-engineering service delivery at the ELC for efficiency is a topic that must concern all of us as we debate and reflect on the past and the future. As we champion the vision, which aims at improved institutional performance and includes the interventions and innovations that we must employ under our vision, I encourage this conference to debate and come up with game-changing innovations and proposals that the court can adopt to ensure that it attains the vision of being a center of excellence in the delivery of environmental and land justice. I encourage the court to continuously work in pursuit of the target of ensuring that its operations provide an enabling environment that ensures our Kenyans get access to justice and also reinforces the integrity of court proceedings while enhancing the public trust in the judiciary. The court should continue in the path of optimizing its operations, the generation and use of high quality and reliable data to enable evidence-based decision-making, and leveraging on automation and digitization of its systems and processes to enhance our service delivery. As I conclude, I encourage the court to continue strengthening its ties with other avenues for dispute resolution in line with the statutory edicts that is provided under Section 20 of the Act that directs the court to use conciliation, mediation, and alternative traditional justice system in the resolution of disputes. Your Excellency the Governor, we have also agreed that we are going to start the alternative justice mediation suite here in Kilifi so that we can promote the mediation and the conversation with the people of Kilifi on how to resolve the land conflict here. Each one of us seated here this afternoon plays the role of one role or another in protecting the environment. That's why we are here, because we associate ourselves with what this court does, either for the land or for the environment. This is either through empowering wananchi, those who work in the civil society. We appreciate what you do by sensitizing them on the importance of protecting the environment. We also recognize the other government agencies, the constitutional commissions, who have put a lot of hours, time and money fighting and protecting the human rights that are associated with the environment and land issues. The core mandate of this court, which is to administer justice by upholding the environmental rule of law, access to justice and land dispute resolution, cannot be fully realized without the input and support of the various stakeholders in the environment and land sector, most of whom I see are here today and will be participating in this conference. So in line with our vision for the judiciary, we work towards deepening the partnership that we have already enjoyed and we continue to enjoy with the county government, civil society, our development partners, so that we can enhance coordination in the administration of justice. I encourage all the actors in the environmental and land governance sector to join hands with the ELC to work towards the realization of the constitutional vision of a socially just environment and land regime. I wish all the participants at this conference very, very fruitful, rewarding, mutual exchange of ideas and learning during the conference. And with these remarks, it is now my singular honor and privilege to invite the Chief Cabinet Secretary to present the message of His Excellency the President, and for him to declare this conference officially open. Welcome, Honorable Chief Cabinet Secretary, to talk to us.
Please be seated. The Chief Justice and President of the Supreme Court, judges, judicial officers, the Chief Registrar of the Judiciary, distinguished guests, and my good friend, the Governor of Kilifi, Honorable Mungaro. Let me also say that I shall follow the President and adopt the very elaborate protocol schedule that was read out here. So, distinguished guests, ladies and gentlemen, good afternoon. I am here to represent His Excellency the President, Dr. William Ruto. There's been a bit of change in certain things. The tradition has been that cabinet sessions are held on Thursday, but since he came in, it's been moved from Thursday to every Tuesday, every fortnight. So today coincides with a cabinet session, and because of the importance he attached to this day, because I was present when he made his commitment that he would come in the Chief Justice chambers, he said that he shall excuse me from cabinet so that I can come here and represent him today. So let me proceed. I am privileged to join you today as you mark this important milestone in our institutional journey in commemorating the establishment of the Environment and Land Courts. The people of Kenya concretized their firmly-held conviction that the historical context with colonial claimants must be resolved in favor of Kenyans. The Constitution therefore determined for all time that Kenya is our home and that this land is our land. The establishment of the dedicated institutions for the governance of land and environment is an extension of this aspiration and affirms our commitment as a people to steward our resources as faithful trustees of present and future generations. The land and environmental governance is a domain characterized by interesting tensions that must be resolved to accommodate our aspirations for development and concern for ecological integrity, intergenerational equity, land and environmental practices that are also expressions of communal and cultural identity, and the relationship between modern science and indigenous knowledge systems in conserving biodiversity whilst actualizing economic growth. As a charter to inspire Kenyans in their quest for sovereignty, equality, sustainable development, equity, and sharing of resources, and other national values and principles of governance, our Constitution calibrated a sustainable balance to arbitrate inevitable tensions while firmly steering the nation along a progressive and radically transformative trajectory. Natural resources are vital for human well-being and national development and economic growth. In Africa, the legal system pertaining to land and natural resources has overwhelmingly tended to reflect exclusive and unlimited access by powerful groups, accompanied by their exclusion and marginalization of a subordinated majority. In other words, the institutional framework around land and environmental resources has traditionally been characterized by severe coloniality even after the achievement of independence. This institutional characteristic is a key driver of poverty and inequality and an insurmountable barrier to the attainment of sustainable development. The promulgation of our Constitution as an intentional instrument of decolonization in 2010 therefore represented the realization of the fundamental aspiration driving the bitter resistance to colonialism and brave struggle for independence. This driving force was the quest to regain control over land. Similarly, Kenya's history with regard to natural resources is firmly united with our people's struggle for environmental justice. Once upon a time, state power, government institution, the legal framework, and judicial decisions were organized to achieve and maintain the effective expropriation of Kenyans for the benefit of a colonial minority. Today,